Well, welcome everybody to the Level Up Consulting Partners webinar, Data Subject Access Requests, Effective Design and What's Required. My name is Dave Cohen. I'm a director here at Level Up Consulting Partners, and I'm going to be your host and the moderator for the program today. We're going to get started in just a minute, but before we do, I wanted to share a few program details with all of you. For those of you wondering about getting a copy of the slide presentation you're about to see, we'll be sending out a follow-up email just a day or two following this broadcast. And that email will include a copy of the slides in PDF form and a link to view the recording. We also want to let you know that we hope that this will be an interactive event. So we encourage you to post questions at any time using the Q&A function that's probably at the bottom of your screen. So please don't be shy about questions. And we're going to take questions both throughout the program as they come in, and we're also going to be saving some time toward the end of the program to have a designated Q&A time then as well. So with that, let me kind of share quickly with you what we've got in store for you in terms of the structure of the program. In just a minute, I'm going to introduce our guest panelists today. Then we're going to start with a short section of fundamentals, provide some definitions and context for those of you that are relatively new to this topic. And then we're going to get into the legal requirements and one of the major drivers for setting up a DSAR or consumer rights program. And then we're going to talk about what this really means in practice at your organization, operationalizing DSARS, as we've put it here, the nuts and bolts of actually setting up, being able to handle these requests, and the things you want to take into account when you're doing that. And then, as I mentioned just a moment ago, we'll save some time toward the end for our questions, and we do hope that you have some. And so with that, let me go ahead and move forward and introduce today's panelists. Donna McPartland is Privacy Officer and Data Privacy and Cybersecurity Lawyer. And Donna, it's great to have you with us today. I want to share with folks a little bit about your professional background.
Sure. Thanks, Dave. Great to be here. Thanks for inviting me. I'm Donna McPartland. I am, as Dave mentioned, a privacy and cybersecurity lawyer and privacy officer. I'm currently in private practice. I started my own privacy firm, McPartland Privacy Advising, and I'm also of counsel at Hans Santos. I work with clients in a variety of industries, including financial services, technology, ed tech, testing, education, and nonprofits. The majority of my career has been in-house in chief privacy officer roles and head of compliance. Recently, I was the chief privacy officer at the College Board, which owns the SAT and all those fun exams. And before that, I was in a similar role and head of compliance at the owners of the GMAT exam. Longtime member of the IAPP. That's how I initially met Dave years back. I'm a fellow of Information Privacy, Certified Information Privacy Manager, and Certified Information Privacy Professional. So looking forward to our discussion today. And with that, hand it over to Will.
Thank you, Donna, and thank you, Dave, for the introduction. I also hearken back to the IAPP, which is where I know Dave from. We spent many years working together across New England and at many conferences. So I'm a director at Level Up, and I've spent the last 15 plus years working in data privacy and data protection. I like to say that much like Donna and Dave, I'm sure we were getting used to data protection before it was kind of a known thing in common society, and people often wondered what we did for a living when we told them we worked in data privacy. In fact, my children thought I was a spy for many years, so not quite as cool as that, I suppose, but I let them believe it for a few years. So as I said, prior to joining the team here at Level Up as a director, I worked at the IEPP, and then I went to work at Promontory Financial Group as part of their global privacy practice, and spent 7 years there working, fortunately, all around the world, helping global organizations, whether it was assessing their programs or implementing privacy programs as well. And obviously, with the advent of the GDPR, that sprung everything to another level. And a lot of the work that we did over the years included developing out or supporting or implementing whether a data subject request for individual rights programs. And that was initially obviously for clients in the EU, but over the last few years with the growing number of laws and regulations in the US, also helping companies across the US to develop out their data subject rights programs. And looking forward to today's discussion.
Terrific. Thanks very much, Wills, and thanks, Donna. Really appreciate both of you making time in your busy schedules to have this conversation with us and to share some of our experience and expertise with the audience there. And on that note, let's go ahead and get started. Let me proceed. So we're going to talk a little bit about the fundamentals, as I mentioned, and provide you with some definitions and context for why we're talking about this topic today. And for those of you that have more experience with setting up these programs, hold tight. We're going to do a relatively short section for those that are really new to the topic, and so people have the foundational knowledge that they need for the rest of the discussion. And as a matter of fact, if you care to, if you want to put into the chat section there, whether you're relatively new to this topic, you're coming here to kind of just get your feet on the ground and learn about what these consumer rights programs are all about. You just type in new or have some experience, which means you've got a program in place and you're looking for a little bit more, or you have quite a bit of experience and maybe you're just looking to tweak and refine your program. So new or some experience or mature. And if you just kind of pop those into the webinar chat, that would help us kind of gauge our level of detail that we'll provide during the conversation. But for those of you that are fairly new, let's talk about some basic definitions here. So what is a DSARS? Stands for Data Subject Access Request. And in preparing for this program, we all were kind of talking about how that is a term that comes from the GDPR. And specific to that law, but that's just in general use in the privacy community. However, to be more accurate, consumer requests is a term that is very commonly and generally used as well as maybe a more generic term that's a little less jurisdiction and privacy law specific. So what is a data subject access or consumer request? It's a query by an individual requesting access to the personal information that an organization has stored on them. The term DSAR comes from the GDPR. So it is the personal information, the data elements that any organization has in their databases about an individual, and it's really at the core of a lot of the world's privacy laws that allows individuals access to that information a company has stored on them. So who can submit one? Anybody that can submit one. However, what's important, and you'll hear more about this later as we continue the conversation, in terms of the laws, not everybody is legally able to receive the information. So in other words, companies are not legally obligated to provide this information to any customer or consumer, although some companies have made the decision to provide it to whoever asked for it. We're going to talk quite a bit about that organization-wide decision. But anybody can submit a data subject access request. There are also some groups out there known as authorized agents that submit requests on behalf of a group of individuals, and we're going to touch on that subject as well. And through what channels? Any communication channel is valid. That's important. Multiple channels need to be provided for by organizations prepared to respond to these requests. However, web forms, emails, and phone are probably the most common channels that are utilized. So hopefully that provides a little bit of a basic understanding of what we're talking about here. And why are we here to talk about this? Why are they important? Well, the number one reason, and probably the driver for most organizations to set up these programs, is legal compliance. So as mentioned here, the GDPR and the California state privacy law, the CCPA, are probably the two best known privacy laws globally that require organizations to provide this service to their customers and consumers. So, however, especially for companies that have a heavy B2C part of their lines of service. It's oftentimes just considered good customer service too, just good responsiveness. Having a strong DSAR or consumer rights request program in place at your organization demonstrates sensitivity to your customers and responsiveness, which is of course essential in today's world. More and more people are making decisions on who to do business with based on their ability to get in touch with the organizations that they're doing business with and the types of responses that they receive. So it's very much considered just a good customer service best practice to provide these services. Data minimization is another good reason to have a strong, robust DSAR program in place, because a predecessor to having a DSAR program in place is to do a data mapping or information mapping exercise at your organization to understand where your company is storing personal information and how it's being used, what business processes is it being used by. And by going through that foundational exercise, you're going to learn a lot about where your information is being stored, how it's being captured, how it's being used. And you will inevitably, as we, Wills and I, and Donna, I'm sure as well, know from working with our clients, folks discover data stores that are no longer in use, just sitting around, and that represent a risk to the organization, but no value or benefit. So by deleting or minimizing those stores of personal information, you're reducing organizational risk and making the operation leaner too. So there are some operational benefits, data minimization, that come from setting up a DSAR program. And of course, it's an essential part of a comprehensive privacy program. So really, again, at the core of most global privacy laws is this ability for citizens, data subjects, consumers, customers, all the various terms that are used in the laws, to be able to submit a request and receive information about the information being held on them. So those are just a few of the many good reasons to set up a robust program. And so with that, let me transition over and hand it over to Donna, and she's going to go over some of the legal requirements for setting up a consumer rights program. Donna, over to you.
Thanks, Dave. So before I dive into the fun legal requirements, which I know everyone is just very excited to hear about, just wanted to note that what I'm discussing is for educational purposes. It's not legal advice. With that said, I would be more than happy to work with you as your lawyer, so please do reach out, and my contact information will be at the end. So on the next slide, we're going to look at the basic requirements. These are what we generally see from the GDPR and many US states now of what rights individuals have with respect to their personal information or personal data. So generally, the right to be informed, the right to have access to their personal information, the right to correct it should they find errors in it, the right to deletion or the right to erasure, and there's some limitations on those rights, right to restrict processing, data portability, which means getting a copy of your data in some type of readable format or something that could be transferred. And then finally, automated decision-making and profiling restrictions, kind of being able to restrict it and knowing what's going on in those areas. So, there's a number of reasons to have a process and policy to respond to these consumer requests, with legal requirements, of course, I think being at the top of that list for most organizations. I do want to note that there has been a slew of state laws, data privacy laws passed recently, and I think we're going to continue to see that. So there are differences and nuances to each of these laws. So with that, let's look at the next slide. The similarities and variations are by jurisdiction normally. So GDPR, the EU General Data Protection Regulation, for folks that may not have heard of that, applies to member states in the European Union, but that really sets the stage for individual rights for US state laws like California, Colorado, and there's so many now, I think we're up to 14. So we're seeing states following GDPR, adding their own nuances to individual rights and certainly other areas as well. And some of them can be quite complex. So we're going to look at a sample policy as I kind of go through my discussion as well. And there we just have some of the states that have passed laws that have these consumer rights in them related to personal information. So with that, let's look at the next one. And actually, I just wanted to note with the similarities and variations by state that in addition to passing these data privacy laws, there's regulations that are passed so that whether they have, like in California, there's the Consumer Privacy Protection Agency, referred to as the CPPA, or some type of other agency or AG enforcing the law, they have regulations. These regulations in California, at least, have been disputed, and there's a recent lawsuit that was brought by the California Chamber of Commerce against the California Consumer Privacy Protection Agency. And a district court judge actually held that enforcement of the CPRA regulations, which were the amendments to the California Consumer Privacy Act, were not enforceable until a year after they were enacted by the regulator. So that brings us into March 2024. So there's a little bit of question. We'll see if maybe other stakeholders try to bring lawsuits related to enforcement of regulations related to these state privacy laws. I do note that the California Privacy Protection Agency has indicated that they're going to appeal this decision. So it's kind of still up in the air. And then also on their website, they have a whole FAQ section where they indicate that they are enforcing the regulations. So they're, they have a bit of a different perspective. So a little bit of uncertainty there, and we'll just kind of keep track of that. On this slide, this is a helpful resource from the IAPP, and I think Dave has the link there at the bottom, but it shows kind of all the states that have actually passed data privacy laws recently in that bright green. I think it's important just to see kind of the increase, and also looking at the states that are in the dark gray. Those are states where bills were proposed for consumer data privacy legislation and are inactive. I think they're likely to become active in the next legislative session. So I think it just gives you an idea, of, first of all, the patchwork of all these consumer data privacy laws and kind of all the differences that occur as well. Mm-hmm. And then the likelihood that we will see more. Go ahead, Dave.
No, Don, I was just going to say, and important to note that this slide, this chart becomes out of date frequently. It was updated relatively recently, as you can see, August 4th of this year. However, it's already up to date, and we're going to be talking about that a little bit later. But just an important note to, again, there's a live link on this slide. When you get a copy of the slides, you can visit the website at the IPP, and I think they try to update it as frequently as they can, but it frequently goes out of date.
Right. So with that, we'll look at the next slide. This is just a different view of it, has the effective dates of each of these laws. And we just want to add Delaware was just signed by the governor, so that needs to be added as well. To Dave's point, this may be a little out of date. We'll talk about that, talk about Delaware a little bit more later. So just kind of putting this up there on the next slide, I think it's helpful. This shows you when the different states' consumer data privacy laws go into effect. So that means that's when organizations have to comply if you're within scope of those laws. And I think it's helpful to understand this for compliance purposes, right? So 2024, we have a number of states coming up. 2025, I think there's a few more to add to that as well, with Delaware being on that list. So just kind of helpful to understand how you're going to prioritize your compliance in this area as well. And then we have a consumer rights slide as well. I think that's the next slide. And this just gives you kind of an overview of those rights that I talked about at the beginning. So it's helpful. This again is another resource from the IAPP. Lists out all the states. I think it's helpful because it shows patterns. So you see states, that are kind of more consumer protective. They're allowing more rights for consumers, like California, Colorado, Connecticut, Virginia. And then some states that are taking different approaches and being maybe more business friendly, like Iowa and Utah. So helpful. This, I think, is helpful for me just to see those patterns. And again, kind of as more states pass laws, we'll see. Unfortunately, I think the pattern is variances and differences, which makes it very difficult from a compliance perspective to follow the array of compliance requirements. So,
yeah, Dawn, I was just going to mention that some folks online know this, but if you're relatively new, there's good news and bad news here. The good news is that there is some copying and pasting going on from law to law, so you should know that there is a bit of a core similarity in most of these requirements, so that when you set up your program, you likely can accomplish handling your consumer requests for a number of different states with a kind of a core program. However, the bad news is there are some subtle differences, and each state seems to want to just change a little bit of something here or there. So you do need to pay attention to each particular law, what they're offering, in order to be in as close to compliance with the law as possible, to understand those nuances and differences.
Right. And you can kind of see in the laws the different factions that are influencing the laws too. So it's interesting and complicated, to say the least. So with that, we're going to look, I think, at some trends, more trends we're seeing in these consumer privacy laws at U.S. state level primarily. So really, I think one of the big takeaways is the opt-out rights for individuals are expanding. So for instance, under GDPR commonly is an opt-in regime. So you have to opt in to marketing and a number of other things. The U.S. states take a different perspective for the most part. Some are, I think, one or two has opt-ins, but it's this opt-out. So you're opting out of a number of things now. They're giving individuals the right to do this. From that chart we just looked at, we saw this. So there's a real focus on, at the state level, to allow individuals to opt out from any sale or sharing of their personal information. And we're seeing very expansive definitions of both sale and sharing. So under CCPA, sale is defined as basically any exchange. So whether it's, getting something, you're giving somebody personal information and they're giving you money back, or you're renting it, you're somehow disclosing it to them, and there's something of value. So it doesn't even necessarily have to be money. And then under CCPA, at least, sharing is when you, again, are disclosing it, but it's a bit more nuanced. So it's to a business or a third party for cross-contact behavioral advertising, which is targeted advertising, basically. And then there's something, whether or not there's money exchanged, it doesn't matter. It's still going to fall into that sharing. So this is a pretty complicated area. I'm just going to touch on it because we could spend the whole session on this. But I just will kind of caution folks, just be careful with these third parties or businesses you're working with, having a service provider agreement in place where it specifically indicates how they're using any of your personal information that you may have about customers or the like. And it's really limiting that.
And Donna, if I could just jump in and kind of underscore what you just said. Wills and I both know from our experience working with our clients that this bit that we're just talking about here, the sale and sharing of information, and in particular with regards to business processes involved in marketing, is an area that you really, especially if you're new to this process, you really want to spend some time and do as much digging as you can, and have as many communications, set up as many meetings as you possibly can with, in particular, the marketing department, to figure out what your organization is doing with regards to this, because it's usual to find surprises, surprising uses of information that parts of the organization might not be aware of. And so a good opportunity to tighten up compliance with this aspect of these laws by looking at these examples of sale or sharing. And in particular, something that trips people up quite often is the fact that it does not have to be necessarily for a monetary exchange.
Right, right. Yeah, and I mean, I think it ties back to doing, your data inventory and mapping. As part of that process, you learn all sorts of interesting things that are going on within your company. And, this is one area, and certainly the regulators, California especially, is on this. There is a definite settlement with Sephora, and this was one of the key findings from that. They didn't have a specific agreement with their third parties that were processing personal information on their behalf to kind of really carve out that it was just for Sephora and wasn't for their own commercial purposes. So I think we'll see more in that area, definitely. Just also want to note that the many states now are giving individuals the right to opt out of the processing of their sensitive personal information. California kind of started that. And I'll take Colorado, for instance. The definition of sensitive personal information is really expanding to include, immigration information, citizenship, race, ethnicity. It's just really broadening. So I think, again, you may have folks that, and in Colorado's case, children's data as well is included in the definition of sensitive personal information. So you may have folks within the organization that think, oh, like race and ethnicity, we've always collected that, and that's, not sensitive data. It is, depending on what state you're in. So just kind of think about that as well. Targeted advertising, we kind of touched on. So most states now are really providing individuals this right to opt out of targeted advertising. Under the Colorado Privacy Act, specifically, I just want to their definition is displaying to consumer ads that are selected based on their online activity. So, yeah, and they're kind of looking at it broadly, very concerned about targeted advertising to individuals, making sure that they have the right to opt out of it. And this kind of ties into the whole, if you don't want third parties you're working with doing that, make sure you have a pretty tight service provider agreement with them. And then finally, profiling as well. More in, this started with GDPR and automated decision making. Profiling generally is when you're using the person's personal information to evaluate their preferences, economic situation, health conditions, things like that, really sensitive areas. And there's some type of, significant impact to them from that automated decision. Here, it's when, there isn't necessarily human involvement, and it's just kind of a decision based on, the evaluation of their personal information without having that kind of human in the loop to really fine tune and make sure that it is the correct decision that's being made. So that's another big area of focus as well. The other area, which we've seen enforcement again as well, is these universal opt-out signals, global privacy controls. And for folks that don't know what those are, so me, just as a consumer, I can use go into a browser like maybe Brave, DuckDuckGo, one of those, or some type of browser extension to basically prohibit businesses that are recognizing these from sending me, using my information to sell it or to share it with others or for targeted advertising. Now, I think this is fairly nascent. I have there the states that have these requirements. California is enforcing this. I mentioned that Sephora settlement that was back in December 2022. And in that, and then the Attorney General in California made some other statements clearly indicating that businesses must recognize these global privacy controls enabled by consumer, in addition to having the link. So you may have seen, for various websites that you visited, it may say, don't share my information, don't sell my information, or California privacy rights, things like that. So this would be, in addition to that, actually recognizing these signals that, again, if you used a browser or had some type of browser extension to enable this, would recognize it. With the Sephora decision, so California, the regulator, the California Privacy Protection Agency, they have guidance as well on their website that they're going to enforce this. And I think that we're going to continue to see enforcement. One thing with the Colorado Privacy Act and the regulations, the regulator is actually supposed to issue additional regulations. In this case, the regulator, I believe, the AG, the Consumer Protection Agency in Colorado, additional regulations indicating what are acceptable global privacy controls. So, and you see here the effective dates vary for each of these states. So again, you have this patchwork of compliance, different dates. We're still waiting on like what is acceptable for these GPCs. So this to me is a very unsettled area. And quite honestly, I don't think consumers are very aware of this, or there just isn't a lot of kind of education in this area as well. Yeah. But that's something to stay tuned, and we'll see how it develops.
Yeah, Donna, just to kind of chime in on that last bit, again, from Will's and I perspective, when we're working with our clients, there's a little bit of a danger in, well, we'll just wait until those regulations get finalized, because a lot of drafts are posted on a regular basis. California and Colorado posts drafts. And the drafts do change iteratively, but you should know that drafts are posted, and that they're, especially as you get a little bit closer to deadlines that are posted, they're pretty much there. And it's probably not a good idea to wait until regulations are finalized before you begin your steps toward compliance, because there is enough information there to get started. And that's certainly something that we advise our clients to do.
Right, and as I said, California is enforcing this, so it's already happening, unfortunately, or fortunately, depending how you look at it. So with that, was going to talk about sample policy. So a sample individual rights request policy. As we've kind of talked about, Dave and I, so there's DSARS, this data subject access rights request. That's GDPR kind of lingo. Different state laws like Colorado have different terminology. So, we're referring to it within, for this discussion, as consumer requests. Things that I've worked on, I've used the term individual rights requests as well. So this is actually a sample of a policy and process that I worked on for a client that was subject to both GDPR and the Colorado Privacy Act. Client was a nonprofit. So most of the state privacy laws do not apply to nonprofits, but of course, that's changing a bit too. Colorado does, although the scope for this act to apply is quite big. I think it's 100,000. Or, if you have revenues from targeted advertising, the sale of data, then that scope is decreased. But now we have Oregon and Delaware as well that apply to nonprofits. But just wanted to walk through this kind of quickly. You can see, this is how some processes could work when you want to have it respond to these individual rights. And I think I strongly recommend that you do have a policy for all those reasons Dave said at the beginning, but certainly your legal requirements as well. But first, you need to verify who the individual is, and that's kind of a process in itself, right? So how do you know they are who they say they are? What are you going to require for them to prove that, basically? I did read today there was a decision from the Netherlands, a company, and this was of course under GDPR, but a company was requiring a photo ID to verify these individual requests. And their request was for both personal data, but also for sensitive personal data as well. And the regulator held in that case that that was not appropriate under GDPR. You could only maybe do it for the sensitive data to have the photo. You want to think about, how you're making sure the person verifies their identity, and is it proportionate to kind of the information that they're requesting as well. Then this is another big question when you are creating your policies and processes. Do you want to have this universal approach where you're offering all the rights to all, or do you want to limit it based on the jurisdictions? And we're going to talk about that a little bit more. And then the rights that may be honored, right? So there's different rights under GDPR and under Colorado. I think Colorado is helpful because their regulations are quite complex. They give individuals a lot of rights. GDPR, certainly has robust rights as well. But just here, you can see some of the differences, right? So you have to give the person access to their personal information, including specific pieces, right? So you can't just, it may be difficult to provide a summary, but giving them the actual pieces of information and give them the rights that we talked about as well. They have universal opt-out mechanisms. And Colorado is distinct because it has this appeals procedure. So if a consumer submits a request and it's rejected, they can appeal that. A few states have this appeal right, but it is not across the board. California does not have it, and a number of these newer states, I don't think, have it as well. So that's something, obviously, important to understand if there's an appeals right and how you're going to have that work out.
Donna, to state the obvious on that point, if you are going to make decisions to reject these requests, very important that you document the rationale behind that, for obvious reasons, because this appeals right does exist for certain state laws. And we've when we build these out, it ends up, some clients do decide, some organizations do decide to make these, just build it into all of their processes as well to take care of it, just to be on the safe side. And there are time limits, Donna, right, too, for the time within which you must respond to the original request and the appeals. So pay attention to those.
Right. Yeah. And it's usually 30 days. And I'm just looking at my notes. So right now, from what I have, Colorado, Connecticut, Montana, and Virginia, I believe, have appeals rights. So there's a few. But yeah, so I think, this just lays out how a process could work to respond to individual rights when you're looking at it as kind of a jurisdiction by jurisdiction basis.
Yeah. And Donna, one more thing about the appeals process, just while we're on that, just so folks out there know, if you're starting to think about, well, how am I actually going to, enact this operationally, and Will's probably touch on this as well. You should know that there are some software platforms that have processes that you can put into place, that you can automate this and just build an extra step on the back of your request process for that appeals process. It's very similar, just uses different language so that you can work toward compliance by providing that extra step of the appeals process. Likely not to be high volume or used very often, but again, because the law spells it out, good to have that in place in terms of compliance.
So, and I think next slide was to you, Dave.
Yeah, great. All right. Thanks so much, Don. I really appreciate that. Hopefully that gave
Sure.
folks a good kind of overview and then actually got into some of the details about the legal requirements in setting these programs up. And really this slide, really we put this together just the other day. You'll see September 12th, as Donna mentioned earlier, Delaware, the latest state to sign into law, privacy law. There's not a lot of information out about it yet. The state of Delaware did state that they were going to be providing a consumer education no later than July of next summer. So I'm sure that they're starting to put together their information to inform individuals and organizations what their rights and obligations are with respect to this new state privacy law. Some of you that are following the broader privacy news trends know that as these state privacy laws proliferate, some say this puts added pressure on their federal privacy law, which those of us that have been in the space for a while have been hearing about year after year after year. However, who knows? Maybe one of these years we will actually see one. So as companies continue to become frustrated at having to comply with, again, this patchwork of state privacy laws, these obligations build. So
yeah, and I just want to note, Dave, this Delaware law, I had looked at it kind of quickly, but this is one they just have weird, bunch of nuances too, from applicability, just to all sorts of things. So unfortunately, this is continuing that pattern of more variations versus more,
more variations.
Coordination.
Yes, and Donna, also some strong requirements. I also noticed that the thresholds are relatively low.
Right.
Yeah, so
it's a tiny state, so I understand, but it's
yeah. So you may well be surprised to fall into scope of this law. Yeah. So then with that, we kind of put this together as a segue between Donna's section in terms of legal rights and what Will's is about to talk about in terms of how to actually put these requirements into place at your organization operationally. One of the big decisions that companies have to make is, as we alluded to earlier, universal rights. So in other words, might it be easier to honor every consumer request that comes in, regardless of whether we're legally obligated to do so or not? As we mentioned earlier, you do have the right to refuse some of these requests if they come from people that are outside of a state that doesn't have a state privacy law in place, or a part of the world that not subject it to the GDPR or another privacy law. So, however, there are pros and cons to rejecting them. Some of the arguments for setting up a universal rights program to provide them to everybody are it can be easier to operationalize as one streamlined approach. More resources might be needed to provide, but a downside could be that more resources are needed to provide that approach. But an upside, again, is that more customer trust and engagement can take place. Back to that earlier slide, we were talking about being sensitive, especially if you're a B2C company and you have a lot of interactions with your customers, a lot of repeat customers. You might want to err on the side of building that customer trust and honoring rights instead of rejecting a right and potentially putting tension or friction between you and your customer base. But the jurisdictional approach, some folks and organizations that make a corporate-wide decision to go that way, there are resources that are required for each jurisdiction's requirements. Some organizations decide that there's some inherent legal risk in providing rights to folks that aren't legally obligated to. The legal teams can at times be conservative that way and not want to provide these rights to anybody that's not absolutely by the letter of law obligated to them. So it depends on risk tolerance within the organization. There's no right answer here. It has a lot to do with size of the organization, sector, again, B2B, B2C, issues like that. And again, we're going to, I think, talk a little bit more about that. So with that, that's probably a good segue to hand it over to Wills.
Yeah, and I don't know if you just want to hold on that slide for a little bit, Dave, and I'll give some of my thoughts around what I've seen with organizations dealing with this issue of, do you provide universal rights or don't you? And I think it's a genuine challenge for organizations to decide upon. And I think, as you quite rightly said, there's no one size fits all here. And I think you have to, as an organization, look at your risk model and look at what what your client base is, and kind of make a risk-based decision as to which direction you feel is best for you as an organization. And what we've seen play into that decision with other customers that we've worked with is, as you said, Dave, it's, what industry are you in? What kind of data are you collecting? What states are you in, etc. And I think a good point here is, when you're saying about B2C or B2B, it's also worth considering, if you're in, we've seen this with organizations that live in the e-commerce world or do a lot of business in the e-commerce world, applying these rights, can be seen by them sometimes as being restrictive to their business model. So do they then want to provide those rights across 50 US states when maybe they only have to apply them across currently it's 3, be 5 by the end of the year. Actually, I think it's 4, isn't it? 5 by the end of the year and 12 by, within the next 2 years, and that number is going to continue to grow. But so there is a business decision to make here as well, and it's looking at, if you offer these rights across all of these states where currently you don't have to, as an organization, you've got to balance that against what does that cost you as an organization. Yes, customer trust and engagement is, the yin to the yang, I suppose, in that conversation. And there also, as both you and Donna have said through the previous slides, there are nuances, even with Delaware just passing its own data privacy law only days ago, or signing it into effect. Even now there continues to be nuances, and despite the fact that we are, and again I'm going to cite Donna here again, we are seeing kind of like more collaboration between legislators that they're trying to, or they're realizing maybe that there needs to be some universal approach to the wording and the terminology and the rights, because it has an effect on commerce as a whole. We still do see that there are nuances. I do wonder how many ways you can cut this pie up, because how many ways can you find to define the same thing in a different way? So it almost could be like a quiz show on TV at this point. But they continue to find new ways to define things. They continue to enhance the definitions of personal information or personal data. They continue to tweak the timelines for acknowledging or responding. New rights come into effect, as you mentioned, the right to appeal, which is not a universal right. If you apply this single approach for universal rights, the right to appeal you have to provide to, currently it's not a right that you have to provide in a lot of states. But let's be honest, if somebody's appealing, they're probably not happy with your initial decision. And human nature is, if they weren't happy the first time, statistically, you're going to have a fair few who aren't happy the second time. And then the appeal goes to the Attorney General. And you have to publish the contact information for the AG's office in your privacy notice. Right. So again, as an organization, you have to weigh up, if I apply this right across all states, I'm going to have to provide that contact information when I don't need to. And most organizations are not looking from an operational perspective to open up that floodgate of having conversations with the AG when they don't have to. So I think there is this, it is an ongoing challenge, and it's not going to get easier. I would say that for a lot of organizations I've worked with in the past, 8+ years, the solution has really been to formulate a baseline. If they are operating in multiple jurisdictions, formulate a baseline, because there are consistencies between these laws and regulations, and then manage the nuances. And that seems to be a predominant way that organizations have moved forward, that I've seen anyway. And it's worth considering as well, if you're responsible for the DSAR program, is understanding how your privacy program is more broadly set up within the organization. How do you operate? Are you a decentralized model? Are you a centralized model? Or are you a hybrid of both of the above? Again, if you are completely decentralized and each region is responsible for the implementation of their own programs to comply with the privacy regs, then you probably won't want to do or take a single or universal approach. If you are a centralized program, then it may be something that's easier if you're going to go down that road to implement. So, those are things worth considering. And one last tip that, we've again seen clients implement is your privacy notice is the lens through which individuals look at your organization. It's where you are telling consumers and employees what information you're collecting, what you're doing with it, who you're sharing it with, etc., etc. And I don't need to go down the route of what a privacy notice online is for, but this is where you're going to define your privacy rights to your consumers, to your employees, and it can be used as a gatekeeper. If you do provide notices that are specific to each jurisdiction, you can define in those jurisdictions what the rights are for those data subjects. This can act as a gatekeeper in the fact that, if I live in Massachusetts, for example, I currently have no privacy rights under current laws. So if I was to submit a request, if I went to a website for your organization and it clearly states that these are the states that provide these rights, I'm not going to see Massachusetts. So that acts as a gatekeeper, and it will hopefully, from an organizational perspective, help to keep people applying for rights that you don't then have to reply to and say, I'm very sorry, but these rights don't apply to you. I've also seen then what customers do or clients have done in certain organizations to maintain that consumer trust and engagement is they'll put that formal line in the sand and hope that filters a lot of the requests that they wouldn't have to comply with. But should people still submit a request from Massachusetts, for example, the company would respond. They'd have a standard template that responded to the individual once they'd reviewed it, kind of stating that, you do not have the rights that you're requesting us to comply with. However, in the spirit of we want to provide great customer trust and we value you as a customer, et cetera, we can provide you with a list of the information that the categories and types of information that we collect on you. If you feel you want to discuss this more, please call us at the following number. That obviously you're not going away and fulfilling a full access request. You're not doing a deletion request, but at least you're providing something back to that individual when they do reply. It maintains that customer trust and engagement. And if you have a process for doing that, it shouldn't be a huge lift. So I don't know, Donna, have you seen that with your engagement, something similar?
Yeah, I mean, I think as that sample policy that I provided, that was more of a jurisdiction approach. And I've seen different approaches. So I think what I see, just kind of anecdotally, is larger organizations may have universal rights with some carve-outs, you know what I mean? Because now things are changing too, as you noted, Will, and we've talked about the appeals rights. So I think it's still a bit uncertain with this approach. But I guess in the interest of time, I'll leave it there.
So if we just move on to the next slide, Dave, and and I know as we're getting close to time, we want to make sure that we do leave time for the attendees to ask any questions they might have. So looking at operationalizing data subject requests, again, typically when working with organizations, we try and put together kind of this 5-step process for looking at how do you plan and implement a data subject request program. The first step is doing some kind of data discovery, whether it's from a European perspective, creating your records of processing. And again, if it's complying with the records of processing requirements in the GDPR, that's probably not going to give you the level of detail you need to be able to meet the needs of a fully fledged DSARS program. So you probably would need to look at those if you have those, and look for areas where you need to flush those out so that there's additional information so where the data is moving, both within and without, and outside the organization, and also making sure that the purposes for why that data was collected are clearly defined, just so that that enables you to understand, when and if certain rights apply to that individual. The right to deletion is not an all-encompassing right. Depending on the legal basis for processing, depending on what you're using that data for currently, you may not have to comply with that request. You're going to have to respond to it, but you may not actually have to delete that request. But if you don't know the purpose for which you collected it, and you don't know the legal basis under which you're processing it, it makes it more challenging to give an accurate answer to that consumer. So whether it's creating inventories or data mapping, that's a critical aspect so that you can trace the information through your organization. And then step two, understanding, identifying and educating stakeholders. There's so many different terminologies that are used here. Formulate the terminology, define and document the terminology within your organization, whether it's going to be DSARS, which is kind of the extra A. I'm not a personal fan of the extra A, but it flows in there. You'll see that a lot on whether you're reading on, whether you're Googling it or whether you're reading white papers on data subject requests. You'll also see the more common DSR or DSRR. You'll also come across individual rights requests. So again, it's just defining what your terminology is and making sure that's consistent across the organization. That will save confusion. And then understanding who's going to own the budget for the DSAR process. Again, a lot of this depends on who you are as an organization, what your structure looks like, and what kind of number you expect to see from a DSAR perspective. So if you don't define who owns it, and you don't get the right resourcing, as Dave said, if you wait till the 11th hour, most data subject requests vary between 30 and 45 days to respond. You can extend that under circumstances where it's a complex response. The regulators have not seemed, primarily in Europe, obviously, because it's more established and mature there, have not seemed to be particularly, what's the word I'm looking for, understanding, shall we say, if you as an organization turn around and say, I was not able to comply with the request within the required time frame because I hadn't built a program, or I didn't know who was doing it, or we got more than we expected. They don't tend to have a lot of patience for ignorance is not an answer as far as they're concerned. So understanding who's going to own it, make sure that you have a relevant budget, and also identify kind of the staffing needs. And this is a challenge. Yeah.
Well, just curious, would you say that companies tend to pretty accurately estimate budget needs and staffing needs on the first pass for what these endeavors are going to undertake, or have you seen otherwise?
I would say if you asked 100 data privacy officers at any level, the budget numbers are what they want them to be. I think that might be one time in our world we'll get a universal answer of no.
No, right.
More budget, more budget, more budget.
Yeah, having been there, yeah.
Yes, and Don, you know as well. It's just so easy to underestimate. So please do your best to be realistic. It's going to save everybody time and energy in the long run.
Yeah, I've yet to see a CPO or speak to a CPO who said they walked into the board and said, I need this money, and the board just said, sure. It's like, that's just not the world they live in, unfortunately. And then staffing needs, again, this is such a difficult one, because if you are in the midst of a mature program, then you've probably got metrics and statistics that tell you what you're going to be getting or what you've statistically received for data subject rights. If you are moving into new jurisdictions, or you're just finding that these regulations now apply to you and you've got to put in place a DSAR program, it's very difficult to know what you're going to get. And I think it really depends on, as we discussed before the meeting, didn't we? It's where are you located? If your headquarters sits in a state that's now going to offer these rights to an employee, California, then you may suddenly have found that you're now having to offer rights to people you never had to offer these rights to before. And again, human nature, as soon as there's something new out there and you make people aware of it, there's going to be a subset of people that are interested to know what you hold. We saw that when CCPA came in and everybody put out the online DSAR request forms. They were flooded, but those numbers have diminished significantly based upon reports that we see out of independent organizations like the IAPP. So it's just understanding, you can't staff too low because it puts you in a problem, but if you staff too high, that also creates a budgetary problem. So it is a very challenging situation for organizations, and I know we're running out of time here, so I'll summarize. It's like, make sure your policy procedures are updated and they address the requirements. Make sure that you have governance around your procedures. Make sure that you identify who owns each step of the procedure. Make sure that you create timelines to comply with each step within the procedure. So that means you can monitor where your program is working and not working. If you don't assign responsibilities clearly, you get the old hot potato where everybody thinks somebody else is going to do it, and they keep kicking it to that's John's, that's Julie's, that's Roger's, whatever it happens to be. By the time somebody's taken ownership or realizes nothing's been done, you are now out of compliance for turning that DSAR around. So,
hey, Will, so let me just pop in quickly to say, for those on the line, thank you very much for joining us today. We are at the top of the hour. We want to be sensitive and respectful to everybody's time. So we understand if you need to drop. If you do need to drop, please know we're making a recording. And as I said earlier, we're going to be distributing that via email so you can catch up with whatever you have to miss if you do need to drop. But we're going to take just a few more minutes here to finish the little bit of remaining material that we have so that we can complete the program. Thanks.
Thanks, Dave. So just on the third bullet point of policies and procedures, we talked about privacy notices. Again, make sure you get your privacy rights or your data subject rights correct in these. They're easy pickings for a regulator or a regulatory body. They don't need to come and see you. They don't need to knock on the door. They can sit an intern down and say, here's 50 websites, go and read their, and this is what they've done in Europe. The regulators have sat down and read through your privacy notices. And if the privacy notice isn't in compliance, it's an easy in for a regulator to dig for other things that are not going as they should be, possibly. So make sure your notices are posted clearly, make sure they're accurate, make sure it's easy for a consumer to submit a report. I know we talk about portals here. It's, you have to offer in California 2 methods for submission of your DSARS. Each state, again, has a slightly tweaked way of complying with, submitting your data subject requests. But if you have a portal, it captures the information. If you are a company that has a lot of online accounts, so a lot of the people we do business today in the e-commerce world, you'll create an account, use that as a validation or verification model, and create the portal within it. Create a privacy portal within the consumer portal. So I think in the benefits or the for the sake of moving things along, we can probably jump to the next slide. Providing ongoing training is critical, and that includes, as an organization, monitoring what's going on with the regulations and the changes that are coming, or new regulations that are coming. But it's also understanding that some of the regulations have nuances within them that you need to understand. For example, in Utah, the Attorney General and the Division of Consumer Protection is going to submit a report in July of 2025 after they've evaluated the first couple of years of the UCPA, and then changes might be made based upon what is found or what it comes out of that report. So just understanding the regulation when it comes in is not going to be enough. You need to continue to monitor it, or somebody within the organization needs to monitor it and identify where changes take place so that you don't fall out of compliance. Developing metrics are critical, as I mentioned before. These can show, first of all, if you don't have metrics, how do you have accountability for the program? If you can't report up to senior management how the program is running, then it makes it very challenging to say we need more staff, we need more budget, because the first thing they're going to ask you is why. Provide me reasons, and you need to develop the metrics that are going to enable you to make those requests by saying, we've received X number of data subjects. They fall into the following categories. We've declined X number. And then the critical one is how many ended up in complaints, because that's something you want to try and address. How many of them were you not able to comply with within the required time frame? These are the kind of areas that help a privacy officer in pitching an argument for whether it's greater budget for resources or greater budget for technology solutions to help them to automate what they're doing. And I think, when it comes to automation, a lot of that's going to depend upon your volume. And again, if you don't have the metrics to back that up, it's going to make it a very difficult argument. As with anything, automation is a great force multiplier. It can create greater efficiencies and consistencies in the way the program is run and responses are sent out. It can also deal with the nuances within each state law, because the organization that builds the platform is going to build those nuances in. But again, if you're getting 3 or 4 consumer requests a month, you probably are going to find it challenging to get budget to buy that kind of platform, and it may end up being that you're doing everything on a more manual basis. But again, there's nothing wrong with that. It's just what's right for you as an organization. And I think that's, here, Dave, I think we're just kind of like going back over some of the areas we've kind of talked about. I know Donna talked about authentication and the requirement to authenticate those submitting a request, and making sure that you're not creating additional files just for the purpose of fulfilling a request. However, most of the regulations, if not all of them, enable you as an organization to ask for additional content or additional materials to authenticate the individual. There are also companies out there, third-party companies, that you can use to authenticate the individual as well, should you decide that's something you want to do. But again, that's a cost that you as an organization have to weigh up the value to you. What to return to data subjects, this is always a question. I think, as we discussed a little bit earlier, if it's somebody where they don't have the rights, poor old Massachusetts, I keep picking on you, then maybe a summary report of the data held is going to be sufficient to address those. However, all of the other requirements do quite clearly, or the other regulations do quite clearly state that you do need to provide copies of the actual records held. So we talked this through internally yesterday, and I think we came to the conclusion there really is no value in providing that summary report if you're going to end up having to provide the actual records that you hold anyway. You're probably going to, or potentially, you could leave yourself open to a complaint because a consumer may feel they didn't get the copies of their actual records, and see it as being you putting obstacles in the way to them getting what they want and not allowing them to fully, access their rights. So.
And Will, that just kind of again to underscore that it may seem like a shortcut and a simpler thing to do to provide a summary report. We have heard this from some organizations thinking that this might be a way to kind of save some time. But to Will's point, in the long run, it's not in full compliance with the law for many of these laws, and could create that additional tension, which you don't want, between your organization and the individual, putting in the request. You don't know what that might lead to. Could be further hassles. So it may or may not be a good idea to provide that summary report at the outset.
Yeah. And I think it's a good point, Dave. It's like, in today's world, data privacy is very much a hot button. States are taking it seriously. Consumers are taking it seriously. Companies are now taking it seriously. Even the federal government, that, chances someday we may get a federal bill. Who knows? That's kind of one of those, pick your side of the fence and decide what you think, whether or not it'll actually ever happen. But, it is definitely in US society a hot topic. And as an organization, what you don't want to do is give cannon fodder to a regulator that gives them a reason to come and poke around and look for something you're not doing correctly. So the more you can do, don't cut corners, don't try and look for shortcuts. They ultimately do typically lead to bigger problems, as with anything in life. So it's like, define what you need to do, define the process, define who's responsible for it, develop it out, and then make sure that you're doing it to, best efforts to comply. And if you do miss something, then at least you've got some kind of defensible position that, again, not legal advice, not a law firm, but a defensible position that you can present to a regulator and say, look, we have a defined process. We have people who own this. We have accountability for the process. We are following up and we're doing metrics. We're staying up to date with the changes. It's just, unfortunately, this one slipped through the net for XYZ reasons. And we've addressed that, and we're moving forward.
Yeah. Donna, did you have something you wanted to add there?
Yeah, I mean, I think from a legal perspective, the legal side of the house is going to say, do what's required under the law. I mentioned Colorado and kind of the specifics. So I think, we're well advised to do that. To the extent the state does not have a privacy law or, more lax requirements, to Will's point, you have to be very careful. So again, it's kind of a risk assessment. The risk tolerance of your organization needs to be considered on how are you going to approach these things.
Perfect. All right. I think, did you want to just touch quickly on this, Wills, and then we should probably move toward the conclusion of the program?
Yeah, absolutely. So, I mean, this is really just kind of a summary of what we've been talking about. Decide what state laws apply to you. Decide whether you're going to take a state by state, or I should say jurisdiction by jurisdictional approach, or a universal approach, and then consider what you're going to do for the nuances, if that's the case, if that's the direction you're going to follow. Update and maintain policies and notices, like we said, by monitoring what's going on with new regulations or changes to regulations. But it's the old adage of say what you do and do what you say. So if you fall foul of one of those, then that's when problems tend to pop up. But look at your metrics, define what metrics you need to provide. Again, if it's something new to you and you're building out a program from scratch, don't try and boil the ocean on day one. Don't try and, we're going to provide, we've seen it, companies go in with best of intentions. We're going to provide these 30 metrics every quarter. It's just, you're going to bind up the wheels of the process, and you're not going to see true value in those metrics. So mature the program. Look at what are those metrics you need at the outset? What metrics should you report monthly, quarterly, semi-annually, and annually? And then as the program gets more mature, revise those metrics to reflect that. And again, use those metrics to develop that business case to make sure that you've got the necessary funding and resources, both internal resources and external resources, to handle things like automation, to make sure that you're complete cookies, and the GPC, the global privacy controls, making sure that you are able to identify when you're receiving those notifications and that you're actually complying with them. And we always like to say, try and have some kind of annual event, whether it's the Data Privacy Day or Data Privacy Week that I know the IAPP pushes heavily. Use that to connect all your education efforts and do things, whether it's on a more regular basis, whether it's providing guidance materials, whether it's providing just email updates, but keeping people who are involved in the process up to date with what's going on and the changes that are coming.
Perfect. Yeah. And then the last big kind of overall takeaway here, these are just some things to pay attention to and be aware of. It's not a static process. There's initial capital expenditure to kind of stand up the program, get it up and running. You will have accomplished a lot when you get to that stage. However, the obvious takeaway here is that it is a dynamic process, and so it needs to be revisited occasionally. Need to make the business case for expanding, especially if your volume's going up of your requests coming in. So keep an eye on it and just regularly revisit it for updates. And so with that, thank you very much, everybody, for joining us today. Have been monitoring the Q&A panel. We were able to weave a couple in there here during the program. And because we've gone just a little bit over, want to make sure we give everybody's time back for the rest of the day. So one last time, thank you, Donna, so much for your time, for joining us today for the conversation. It was fantastic. And Wills, as always, great to work with you. And thanks for your time as well. And as you can see on the slide here in front of you, we've provided contact information. You can reach out to us, please do. We love to hear from you, feedback, anything you'd like to hear about in the future. And of course, if you have needs with regards to either legal advice or operational privacy, Donna and Wills and myself would be more than happy to talk with you about that. So please reach out and stay in touch with us. So with that, I'll take us to a program close, and I wish everybody a wonderful rest of your day. Take good care, everybody.
Great. Thank you.
Thank you, Dave. Thank you, Donna.
Bye.